Dangerous Instrumentality Doctrine. It probably doesn't mean a lot to you, but Florida has a dangerous instrumentality doctrine to sort of get rid of the whole idea that you have to prove that the owner of a vehicle was negligent for allowing somebody else to drive their car. And here's how it works, and it's a little scary sounding, but here's how it works. If you own a vehicle in Florida and you allow anyone to drive it, they're called a permissive user. That person is acting on your behalf, whether you like it or not. If that car is involved in a wreck and your name's on the title, you and the driver are equally responsible for whatever happens in that vehicle from a civil standpoint. Now, criminally, you're not, because criminal is a personal intent action, right, against the person that had the intent to hurt somebody or the person that was driving intoxicated or whatever. So you wouldn't be held criminally responsible. But in the civil world, the lawsuit world, you as the owner of a vehicle in Florida are equally responsible in nearly every respect. There are some exceptions. But in nearly every respect for what happens in that vehicle. So, to give an example, a friend of yours has his car's in the shop. And you and he work together. And he needs to run an errand at lunch, and his car's in the shop, and he says to you, listen, can I use your car to run an errand? I have to pick up a gift for my daughter's birthday tonight, and the store closes at 4:30, and by the time we get out of work, it'll be closed. Certainly, most everybody would say, unless you know something about that person's driving history, you would say, sure, no problem, right? Well, and let's say hypothetically the person leaves their lunch hour to go get this gift for their daughter, and on the way to get the gift, they're on the phone. They're texting their spouse about dinner plans for the daughter's birthday, and they run a red light, and they smash into another car. Okay? Well, you're the owner of that vehicle. You are now on the hook for whatever injuries are caused to that other vehicle and the people in it. Okay? And you may say, well, that stinks because I didn't give him permission to be on his phone, right? And to be texting while driving. I assumed he was going to be, not negligent driving. Well, tough luck. The law says you permitted him or her to use the vehicle. They were involved in a wreck. They were negligent. And under the law, you have to deal with it. So that's how that is. It's called the Dangerous Instrumentality Doctrine. There are some exceptions to it. Obviously, if your car is stolen and you report it stolen, then you are off the hook for what happens in the vehicle. If you don't give somebody permission, they're not a permissive user. That's another example of an exception. There's also some exceptions to the amount of damages that can be held against an owner under the statute. So if you have questions about a situation where you're the owner of a vehicle or you are a victim in a car wreck and you have questions about the owner of the vehicle, and the owner and the driver are different people on the wreck report, and a lot of people have questions about that, feel free to reach out to us on the web at zarzaurlaw.com, or you can call us at 855-HIRE-JOE. Thank you.